The Biden administration asked the Sixth Circuit Court of Appeals Tuesday to put its vaccine or test requirement for large employers back into effect after it was blocked earlier this month. Here's where the controversial policy stands now and what to expect next as the appeals court deliberates. Dela. With the reopening of workplaces and the emergence of the highly transmissible Delta variant, the threat to workers is ongoing and overwhelming. In their court filing asking for the full Sixth Circuit to hear the case, state attorneys general argue the OSHA rule shouldn't be upheld because COVID-19, while unvaccinated workers are more likely to die or be hospitalized, a multiple of a small risk is still a small risk, the anti-mandate plaintiffs claim. More than 6,500. That's the number of deaths from COVID-19 that OSHA estimates the vaccine or test mandate would prevent over 6 months if it's allowed to take effect, along with more than 250,000 hospitalizations. How the OSHA mandate will clash with conflicting state policies if it's allowed to take effect. Multiple GOP-led states have imposed policies specifically aimed at combating vaccine mandates, including bans on employer vaccine mandates in states like Texas and Montana and a new Florida law that requires employers to have more exemptions to vaccine requirements like pregnancy or a prior COVID-1. OSHA stipulates on its website the federal policy would supersede any state rules, and some companies in Texas have already moved forward vaccine mandates despite the state policy because of the federal rule, though the issue is likely to end up in court if the federal rule takes effect. The OSHA mandate for private employers is separate from other federally imposed vaccine mandates on federal employees, contractors, and healthcare workers whose facilities participate in Medicare and Medicaid programs.